of which I will pick 2 or 3, because some of them are really subsidiary to those. And then, of course, the merits. When we get to the merits, I will explain that actually there's one issue, which is the interpretation of the letter. The other issue about the failure to advertise really is another side of the same coin, because obviously if there was going to be a fresh application or a new application, as my learned friends want to categorize it, only then would the duty for another advertising, another gazetting arise. But what I really want to do to this court, members of the court, is to demonstrate that it is impossible, we will never be able to get to the merits of this matter. The problems that the ANC has with regard to the preliminary issues are literally insurmountable. They are insurmountable for the reasons that we have pleaded, but they are also insurmountable for the point that my learned friend Mr. Mutau made, which I will demonstrate actually runs through all the preliminary points. And my intention was to start with jurisdiction, but I want to leave this rhetorical question hanging so that when we get to the other preliminary issues, it must remain at the back of our heads. And it arises from what my learned friend Mr. Mutau has said. We have to ask ourselves 2 rhetorical questions. 1, if the ANC understood, not only understood, but implemented the structure of the Act, that you cannot run straight to court, you have to go via the Commission as the statutory appeal mechanism, which is what they did in relation to the, let's call it the trademarks issue. Then, on what basis is another complaint about registration, the same issue, which simply happens to be on another ground? Suddenly, you have a different approach. You now have to jump straight to court, or you are now allowed to go back to court, or rather to go straight to court. It cannot be. The second rhetorical question, which goes to the root of this, is we must ask ourselves, what would have happened if that appeal had succeeded? We know that it was dismissed. If it had succeeded, I think my learned friends will concede, we would not be here today. So the only reason that we're here is because they failed in that appeal, which was decision given on the 24th of November. But not only did they fail, and this comes to, I want to explain what my learned friend Mr. Mutau says is inexplicable. The failure of the ANC to explain all these delays. And I will demonstrate that it is not inexplicable. It is actually part of what we have characterized as the abuse of the court process. Now, here is a party which has, it doesn't matter which term you use. We can call it preemption, we can call it acquiescence, we can call it estoppel, we can call it waiver, we can call it election, it doesn't matter. The legal principle is the same. When the ANC, on the 24th of November, was visited with this dismissal, it had an option at that point to come to this court. 30 days. Once it failed to do so, let's say on Christmas Eve, 24th November to the 24th of December, then it had made an election not to challenge the decision of the commission by coming here. The implications of making that election are far-reaching, because it meant that the ANC accepted the dismissal of its case. We all know that's what happens. That's what the doctrine of preemption is. You get an adverse decision, you have 2 options. You can appeal it, or take it further, or accept it. Their own evidence is that they accepted that decision. They keep on telling, my learned friend, Ms. Baloyi, tells you, go to paragraph 21 of the reply. We make it clear, we are not here to challenge the appeal decision. Please, these parties are confused. They think we're here to challenge that decision. No, we're not here for that. We're here to challenge the decision of the Deputy CEO. This is what they say themselves. Page 205, paragraph 21 of the reply. Now, the implications of making that election go to this mystery of what is called inexplicable. It's inexplicable. The ANC did indeed accept that outcome. They had reconciled themselves with the idea of Umkhonto weSizwe Party being registered in South Africa. Not without trying, they tried, but they reconciled themselves with that idea. So what changed? The only thing that made them to wake up from their slumber was the announcement on the 16th of December by former President Zuma that he would vote for, or he would vote and campaign for the MK Party, which we say that at page 150 of the papers. So it's not inexplicable. It's logical and it's completely inexplicable. What's inexplicable is their refusal and failure to come clean with the court and explain why they waited for so many months. At paragraph 5.19, we say that this application is merely a desperate political reaction to an announcement made by the former president on 16 December that he will neither campaign nor vote for the ANC, but do so for the MK Party, the third respondent. It is unconscionable to abuse our courts in such a manner. Because there's no other logical explanation for a party that has said, look, we tried, we're not going to appeal, we're not going to take it further. And then suddenly, they tell us literal stories about the festive season. No, the reason why we came late was because of the festive season. Please. Which festive season starts on the 7th of September? And rolls on for months and months and months. And then you just wake up on the 7th of January. And my learned friend, Mr. Mutau, is also correct that this court really is being asked to do this. It must overlook the acceptance of the decision of the registration of the MK Party. And then it must also condone the lateness, which has not been explained by anybody. I don't know what the court is expected to do. It must make up the reasons why people who say that we learned about this on the 11th of September and we acted on it on the 20th. But we are coming to you, court, 4 months later in the following year. But we have no reason to do that except that there was a festive season and all sorts of unintelligible things. The court cannot do such a thing. So let's park that, because that also goes to in a way, touches on the merits. Why do we say that this court cannot reach the merits? There is simply no room to maneuver. Because the jurisdiction of this court, and I'll address the presiding officer's remarks about the legality review, by demonstrating that there's no legality review. This is just a contrived, it's actually a third case now that is being brought. The first case that was brought in the founding affidavit on the basis that there's a reliance on Section 20. When it was clear from the answering affidavits that that will not work, a new case was introduced in reply about Section 21 of the Supreme Court Act. When it became clear that that will not work, a new case has now been brought for the first time in court this morning about legality, Section 172, something you will not see anywhere in these papers. Section 172. So you can't, at best, then the parties should be given an opportunity to deal with this new case, which we heard about this morning, of Section 172. Let me cut it very short. In South African law, there are 3 types of declarators that you can get. The first declarator is in terms of Section 21(1)(c) of the Superior Courts Act. That declarator is intended for situations where you do not seek consequential relief. It's basically, courts always say, well, we're not here to give you legal advice, as to whether is this the law or not the law. But that's the jurisdiction of the court. The problem with that is that it has to be based on a contrived argument that this court is a division of the High Court. It is not. Section 21 deals with the jurisdiction, and the opening words are a division of the High Court will do this, and one of them is a declarator. Now, the mere fact that a court is said to be a court with the same status as the High Court does not mean, A, that it is a division of the High Court. Neither does it mean that you can somewhere bring a matter there. Because if that argument that was put up by my learned friend regarding the specialist courts and so on, well, then they should have brought the matter in the labor court or the tax court or the water court or whatever, because those are specialist courts with the status of the High Court. That's not what is meant by a division of the High Court. That statutory court, which derives its jurisdiction from statute, must itself, qua that court, have jurisdiction before you can come with all these arguments that are interesting about how courts, apply flexibility and what have you. So what have we got here? We have a situation where the Section 21 does not apply. The second category of declarators in South Africa is under Section 38 of the Constitution. Section 38 of the Constitution says that whenever there is an infringement on your rights, you may come to a court, and I'm paraphrasing, and seek relief, including declaratory relief. Then the third category is Section 172, 1A, which is now being smuggled through the back door this morning. But Section 172, 1A does not apply here, because Section 172, 1A says that whenever a court is faced with a constitutional matter, you can have a declarator of invalidity and so on. Again, I'm paraphrasing because of time. It is only if they had pleaded, not even Section 38, Section 172, 1A, that the question that the presiding judge was asking would arise. Because as we all know, Section 172, 1B then says, once you have made that declaration, then you must have just and equitable remedy, which is just and none of all this has ever been pleaded. We hear about it for the first time here this morning. So the jurisdiction regarding the so-called declarator is absent, let alone the jurisdiction of the main player. And my lords, my lady, and the members of the court, it is not us who must speculate, or the court for that matter. We say you have no jurisdiction to come here. They, with their eyes wide open, say that, no, you got it wrong. We are there in terms of Section 21 of the Superior Courts Act. They don't say anything about Section 38. They don't say anything about Section 172, except this morning. Can be. We can't litigate like that. But in any event, this is the clearest case, my lady, my lords, and members of the court. We don't need to twist our minds. This is not a situation like those jurisdiction mind twisters in Chirwa, in Taba, and all those things in terms of the Labor Relations Act. Here, the legislature has been very kind, because they've explained the issue of jurisdiction in the clearest of terms. Here it is. Section 20, bracket 1, bracket A of the Act. The Electoral Court may review any decision of the Commission relating to any electoral matter. So to simplify this, let's not quibble about whether this relates to an electoral matter or not. Let's assume that is so without deciding. And we focus on these few words, that the Electoral Court may review any decision of the Commission. Is there a decision of the Commission before this court? No. Absent the statutory boundaries of the jurisdiction of the court, how can this court even reach the merits? Is there a decision of the Commission? No. But what is worse, there was a decision of the Commission on the 24th of November, and that decision was left alone, knowingly. And now, when there's a decision which, on everybody's pleadings, is a decision of the Chief Electoral Officer or his or her deputy, it's common cause. Anybody like me who has ever been employed at a state-owned enterprise will know that there is an accounting officer in terms of the PFMA of such an enterprise, and the IEC has told us that they fall under the PFMA. Those delegation of framework authorities is a PFMA thing. And then there's another body, which is normally a board if it's an SOE, called an accounting authority. A decision of the accounting officer cannot be the decision of the accounting authority. The simplest example is Director General and the Minister. The Director General of a department is the accounting authority, and there are decisions that are at that level. The Minister is the accounting authority, or sometimes there might be some structure depending on the department. But the point of the matter is that an accounting officer has their own responsibilities. They might even be sent to jail for certain transgressions if they don't perform their duties under Section 86 of the PFMA. So what we have here is clearly a decision of the accounting officer. And that distinction is not one that is difficult to make. If you go to Section 6 of the Commissions Act, you'll see it says the Commission shall consist of 5 members, one of whom shall be a judge, appointed by the President in accordance with the provisions of this section. That's the Commission. And then if you go to Section 12, it says, as soon as possible, after the composition of the Commission, so we know what the Commission is, and whenever necessary, Commission shall appoint suitably qualified and experienced person as Chief Electoral Officer. The Chief, subsection 2, the Chief Electoral Officer shall be the head of administration, shall be the accounting officer of the Commission, may exercise such powers and perform all such duties and functions as may be entrusted or assigned to him or her by the Commission or this Act or any other law. Now, as a matter of pure logic, the latter day, another new case that is made in reply is that now the Commission is the CEO and the Commission are synonymous, or something to that effect. I mean, that's just completely out there. And the reason why that cannot be is, again, let's go back to the text. We can take many examples, but let's take, for example, Section 16.3 of the Act, which says the Commission, oh no, let's take 16.2, sorry, is more convenient. Any party which is aggrieved by a decision of the Chief Electoral Officer, that's the accounting officer, to register or not register a party, may, within 30 days after the party has been notified of the decision, appeal against the decision to the Commission in the prescribed manner. So, now, on this argument that the two things are synonymous, that would then mean that this decision of the CEO is a decision of the Commission which must be appealed to the Commission. What is that? It's clear that this is a two-tier system that is designed by the law so that, and this is very important, because these things are not just put here for decoration. There is always an underlying philosophical or legal reason why this is so. Here, the underlying legal and philosophical reason is what we all know as lawyers as the duty to exhaust internal remedies. or if you like, the separation of powers. The law, and this has been said so many times in many cases, Batista, Kumalo, Zondi, and so on. The law, mindful of the fact that there are specialist bodies,
please proceed, Mr.
No, okay, thank you, my lady. The law, mindful that there are specialist bodies such as the IEC, prescribes, let's put it that way, prescribes that when a decision is made at the level, let's say, of the accounting officer, you must then refer that decision to the specialists, the commissioners. They look at that decision, and once, if you are not happy, even at this second stage, then you go to court. So there's an underlying rationale why the court insists that a decision of the electoral officer within 30 days must be referred to the commission. Of course, we know that after that happens, if you're still not happy, you then go to court. So that's the reason. And that reason cannot be circumvented on top of it by a party that knows that the reason for that and has actually exercised it, as eloquently put by my learned friend, Mr. Muta. So unless there can be some, and one cannot think of any, a way of going around the fact that this is not a decision, and on this we are all agreed, all sides. This is not a decision of the commission, but a decision of the chief electoral officer, which by the prescription of law needs to travel the road via the commission before it can ever see the light of day before this court. Now, there's an issue, I think His Lordship, Mr. Justice Adams raised this, maybe indirect. And it is this issue about whether or not the trademarks issue is before us here. Now, that's a very interesting point, because, yeah, and my learned friends are quite correct. That issue is not before this court. But look at this. The issue that is before this court, if you ask that question in the other way, why was it not in that appeal, the Section 16 appeal? The only reason that that issue was not before that appeal is because the ANC failed to inspect the documents on their version until the 7th of January of 2024. That's the only reason. Because we have to assume that when they got the decision, and then they were, if at that stage they had done what a normal person should do, there's a decision to register Mkhonto Sizwe, what? Let's go and inspect the documentation. Then they would have found the letter of the 4th of August. Then that issue would have been formed part of their appeal, and it would have been dismissed or upheld or whatever. Now, they say, no, understatement of the year. The ANC says we could have been more diligent, we accept that. No, you were negligent and you neglected your duty to do what should be done. Regulation 7 of the regulations, members of the Honorable Court, makes it clear. Regulation 7.2 of the regulations says, the register of parties and a copy of every document lodged with the CEO for the purposes of the registration of a party or the renewal of the registration of a party, the changes in registered names, abbreviated names, distinguishing mark, and so on, shall be kept for inspection by the public at the office of the Chief Electoral Officer. And any person may inspect the register, and if requested, a copy of the register to be made available free of charge during office hours. So the regulations have assisted all of us. If I see there's some party called the Sikakane Party or something, then I get worried about it. I must then invoke Regulation 7.2 to go and inspect the documents, and they'll be given to me free of charge. The ANC failed to do this, and without any explanation, tell us that they only did it on the 7th of January. But this court must overlook all these things and give it a hearing.
The ANC didn't raise the issue of the name and the logo. Did I understand you correctly? Of course, my understanding of the appeal was that they specifically raised that in the letter. I may be misreading.
That they specifically?
They specifically raised this issue.
No. That's exactly what I'm saying. Yeah. I'm saying they only raised the issue of the logo and the trademark in that court.
In the appeal?
In the appeal,
the
yes.
Commission, to the commission.
Yes, the commission. That's what I'm saying. I'm saying they did not raise this complaint here.
Oh, I see.
No, they did not raise in the commission appeal this issue about the fresh letter and what have you. Yes.
Because my understanding is that they say, take out that sequence, that appeal sequence, take it out notionally out of the sequence. Forget about that. We're not interested in that anymore. We're now following a totally different path based on legality and ultra vires. And on the basis of that cause of action, we apply for a review and a setting aside of the...
Yes, but that gets into two cul-de-sacs. The first cul-de-sac is the one that we've just discussed now, that decision is not a decision of the commission. I've addressed that. Yeah. But the second cul-de-sac is what my learned friend Mr. Mutawa was painfully trying to explain, which is that had they, and this dovetails with the issue of condonation, of course, and urgency and so on, had they done what I've just read out here, which is to find the information, then surely, because remember they say they got legal advice, surely that legal advisor, even if it was a first-year law student, would have said, I've looked at the papers now, there are two issues. One is the logo issue, the second one is this fresh application issue. Okay. And they would have then put it there. The only reason, and my lord, this is the point I'm making, the only reason that did not happen is because according to the ANC, they were not aware of the fresh application issue. Now, the first words that my learned friends here said this morning was that the test is what you're aware of or what you ought reasonably to be aware of. We all know that from prescription law, from everything. And I've demonstrated that they ought reasonably to have been aware of this prior to that appeal. So that appeal, it's very convenient to come here and say, no, forget about it. No, can't forget about it. That appeal is crucial. And the fact that it is crucial is not our making. They have put it in the papers because they understand that it is part of the logical sequence of this matter. So let's leave the issue of jurisdiction. There is no possible way around the jurisdiction point. Let's then go to the issue of condonation. I'm sorry. Yes.
I just want to debate your response to my question about the legality review. And you deal with it in the context of your argument around jurisdiction.
Yes.
Right. Now, my understanding of the applicant's case is that they invoke the jurisdiction of this court in terms of Section 20 of the Electoral Act. Yes, but really their complaint around the decision they're impugning is that decision is unlawful. Yes. That's their complaint. Doesn't that characterize the application as a legality review? Their complaint is that the decision is unlawful.
Yes, it doesn't matter. Firstly, I will, as I've said, that it's not a legality review, but let's say it is. Section 21A, my lady, does not put an adjective. It says this court will review a decision of the commission, whether it's a legality review, a culture review, or this review, or that review. Okay. This court will review a decision of the commission. So it does not assist them to characterize it as a legality review. So what?
Okay, so the substance of what I put to Ms. Baloyi is that she seeks review relief, and that cannot be the end of the matter. In the event on the merits, she succeeds. Cannot be the end of the matter. There's got to be consequential relief. And that was the essence of what I put.
That was the answer. That's correct, my lady. You see, that answer, my lady, is opportunistic. Let me explain. Go to the notice of motion. You'll see that the first relief that is sought is to review and set aside the decision.
It's the urgency relief.
The first is urgency. I'm just talking about on the merits. Yeah. The first relief sought is the review, and I've already answered that. That's already they're out. The second relief, which they tried now to sneak into the jurisdiction thing, is then the declarator.
But I wasn't asking about that. I was simply dealing with the review issue and the fact that in the event that we are with them, it's not the end of the matter, and they hadn't addressed that second aspect of the relief that follows.
Yes, my lady. No, I agree. So even if they had pleaded Section 172, your ladyship is quite correct. Even if they had pleaded a Section 172 or a Section 1C of the Constitution, pure legality review, your ladyship is quite correct. If it was a PAJA review, for example, that question that your ladyship raises would fall under Section 8 of PAJA. Because Section 8 of PAJA is a mirror image of Section 172 1B of the Constitution. Both of them say it's not sufficient, the point your ladyship is making, to review. You must then have relief to set aside. And that relief is discretionary. The first one is not discretionary. That's why Section 172 1A of the Constitution says the court must declare. Yeah. And then it says may.
Yes. But even the setting aside relief should not necessarily be the end of the matter.
Absolutely.
Because when we do set aside a decision, we've got to consider the consequences of setting aside the decision.
Yes. There's still a further question about remittal, substitution, and all that.
So that question does arise in these proceedings, Mr.
Absolutely. Because that question, if let's say it was properly pleaded, is a matter that's in the discretion of the court because of the use of the word may, and it has to be addressed by the applicant. Your ladyship is quite correct. But what I'm saying here is that A, is not pleaded. B, even if we are generous and say, okay, well, the court can overlook that, as your ladyship puts it, there is nothing before this court.
No, but I'm persuaded by the approach that Mr. Mutau is suggesting, because there's constitutional court precedents about that approach. And it's of proceeding to Part B, issuing directives for consequential relief to be properly pleaded.
Yes. Yeah. Well, my lady, I don't fully agree. Let me explain. Of course, insofar as I'm complaining about non-pleading, then obviously your ladyship is quite correct. We would be entitled to Audi to deal with that issue. Yes. But my issue is this, my lady. That kind of relief is not pleaded before you. The relief that is pleaded before you is a relief in terms of Section 21A, which is the review, or alternatively in terms of Section 21 of the Supreme Court Act. Full stop. If they want to bring a new case, as I say, we all heard about it this morning, under Section 172 1A and B, then I would agree with your ladyship. Then you would say, okay, plead that case.
They don't need to specify the provision. They don't need to do so. If they make out a proper case on the papers that the decision of the IEC is unlawful, then this court would be entitled to review that decision and to set it aside. And the court will have to be concerned about the consequences of setting it aside.
Well, my lady, okay. Well, I don't know if they can really do that. If they can say, let's assume they can say it's a legality review, as the ladyship was saying earlier, successfully. All I'm saying is that it's going to run into the same end of the road. That yes, it's a legality review of what? Of a decision of the deputy chief executive. That decision is not reviewable.
And that's a jurisdiction point.
Right? No. It's now a substance point. I'm saying the decision of the DCEO is not reviewable before this court. And that's what Mr. Mukhale was trying to say in the morning when he talked about immunity. He mischaracterizes our argument to be saying, therefore, that means that a decision of the DCEO is not reviewable, will never be reviewed. I think that's what he said. No, how could we make such a ridiculous submission? Of course, that decision is at a theoretical level reviewable, but you cannot review it directly. It must first be a decision of the commission. And how does it become a decision of the commission? By the process of either an appeal or whatever referral. Of course, there's nothing, how can we say the decision is immune? There's no such thing. Even if it was a decision of the person who sweeps the floor, it can be immune from review per se. But the Act has prescribed what kind of decisions should be. It's like, my lady, I say an accident happens in Durban, and somebody brings the case in Cape Town, and then we say, no, this court doesn't have jurisdiction. And they say, oh, it means then you can just break my leg and I can never get recourse. No, you are just in the wrong court. You are, the harm that you have suffered is obviously justiciable.
Of course, if this court finds that it lacks jurisdiction over the relief sought, it's the end of the matter.
That's it. Yeah. That's the end of it. That's why I was saying, my lady, one cannot conceivably reach the merits. In Makanya, this court said, the question of jurisdiction is not whether you're going to win or you're going to lose. It is whether the court has the power to enter to hear you in the first place. And Zaba, this court, no, not this court, the Constitutional Court said in Zaba, the best way, at paragraph 75, the best way to judge that question is to go to the pleadings. And what do the pleadings say? They are pleadings. They say we're here for a decision of the Deputy Chief Executive Officer. And don't make a mistake, they repeat it in reply in case we didn't hear it the first time. No, we're not here about any decision of the Commission. We're here about the decision of the DCO. To review its legality, whichever way you look at it, but the one cannot move. Then quickly, let me run to the issue of, the leadership is quite correct, that should be the end of the case. But let's quickly go to condonation and agency. I'll do them interchangeably to save time, but because they are related. But here's the mistake that everybody makes in this court. When we talk about agency here, we're not talking about the kind of Rule 612 agency. We're talking about preordained statutory agency. So it's not something that the court can say, oh, well, okay, you know, someone is going to die, and so on.
Mr. Mpofu, I see that it's 1 o'clock.
Yes.
I'm quite happy to let him finish.
If he's about to finish.
If the court is mindful to take a break, can I just round off this point so that I go to the merits? Yes.
Okay. Okay.
Thank you.
Your suggestion is accepted. Your suggestion is accepted. So you round off the point and then you come back and deal with the merits.
Yes. I want, when the court goes to lunch, to consider this, the real scheme of things here. The issue of condonation arises from Rule 6 of the rules of this court. That's the rule that says you have 3 days to bring a review. But the issue of agency arises from the Act. And these two things must not be confused. The agency is at section 20, sorry, and my submission, of course, is that this party fails on both. But section 20 is another simple, the draftsmanship of this law is encouraging. It says, any such review, that was the one we spoke about, of the decision of the Commission, shall be conducted on an urgent basis and be disposed of as expeditiously as possible. Let's forget the dispose of, that's the duty of the court. The first part, any such review shall be conducted on an urgent basis. What does that mean? It means who conducts the litigation is the parties, and who initiates it is the applicant. So if you unpack that, it simply means that by decree of the legislature, not the court, not the people who draft the rules, the applicant must bring the matter on an urgent basis. So you have here a party that has defied not only Rule 6, for which they seek condonation, but they've also defied Section 21B, and they have not asked for any serious consideration of why a peremptory provision of the Act has not been followed, except these stories about festive seasons and so on. So then they have a double whammy, as they say in colloquial language, where they are unable to satisfy the court on condonation for the reasons which I will not repeat of that my learned friend Mr. Mutau, even on the Arise Africa test. Because on the Arise Africa test, you must, firstly, the delay must be reasonable. Here, on their version, they say 29 days. We say it's 100 days, doesn't matter. But the point is that it's excessive, even on the AAR test. It's 4 months. Secondly, you must give a full explanation why there was such a delay. Because they are running away from the real reason, which was the press conference of the 16th of December, they are unable to give a full explanation. Thirdly, you must show that there is no prejudice, or at least the balance of prejudice is such that it can be cured by cost. They do no such thing. Fourthly, you have to demonstrate that there are prospects of success. How on earth can there be prospects of success when you are in the wrong court? When you are here to bring a matter that is, let's even not go to the merits, I'll do that after the break. But just within the house of preliminary points, there's no prospects of success at all. So of course, AAR, this court said in AAR and in Glenister and other cases, that none of these factors on its own is decisive. But it doesn't mean you don't have a duty to address all of them. You have a duty to do so. So the matter A is not urgent. B, the condonation sought can never be granted on any test that is conceivable. And I would rest.
I'd like you to deal with, are you rounding up the agency?
I'm rounding off that point, my lady.
There's an issue they raise about agency, and it's the second leg of the test for agency, that if we don't hear them, they will not have substantive redress in due course. And none of the respondents have dealt with that.
Well, we've certainly dealt with it in the answer of Adv Dali. I'll give you the reference when we come back. But let me answer it like this. Firstly, as I don't want to repeat myself, that this is not a Rule 612 kind of test. But let's assume it was for a minute. There are two legs, your ladyship is quite correct, of the test for agency. One is agency that is self-created cannot cut it. The second is that the party must show, the point your ladyship is raising, that they wouldn't otherwise get redress in due course. On the self-created agency, I've addressed that ad nauseum with all the chronological sequencing that I've done. It's patently clear that the agency is self-created. Now let's come to the relief in due course. Here you have to postulate, my lady. You can't slumber for 6 months and then come to court and say, oh, well, I won't get relief in due course. No. Assume they have done what we have now all agreed they should have done. Assume that on the 7th of September 2023, my lady, when they received the news of the registration of Umkhonto weSizwe, they had done what the Act says they must do and lodged the application, let's be generous, at the end of September. Then we would have answered and replied, all of us, by end of October. What would have stopped this court from hearing the application in due course? I dare say this court would have sat even before today. So if they had brought the matter as they were duty-bound to do, then even the second leg of the agency test, which is the hearing in due course, you can't come here now and say, no, the elections are now next week. Because you have created that situation, and had you acted as you should have, the matter could have been heard in due course. So they fail on both legs, even if you are generous and use the Rule 612 standard, which we shouldn't be using, because this is a statutory agency of a parental nature.
So you're saying only the first leg applies in this court?
No.
Is that what you're saying? No,
I'm saying, my lady, I'm saying something different. I'm saying more. I'm saying more than the Rule 612 test should apply here, because we're dealing with statutory agency of a peremptory nature, unlike the agency that we all deal with in the High Court. But I'm prepared, for the sake of progress, to say, let's even use that lower standard of Rule 612. And I say they fail even that lower standard, let alone the higher standard I'm postulating of a statutory test. They even fail the normal Rule 612 because A, it's self-created, B, the matter could have been heard in due course. So it cannot be condoned because they have not pleaded any condonation grounds. It doesn't fit with the AAR standards, it doesn't fit with Glenister, but at the same time, it is not urgent within the meaning of Section 21B. Those are our submissions on the agency stroke condonation.
We adjourn until 2? Yes. We adjourn for lunch until 2 p.m.